Mike Brown, the former FEMA director.
Joining us here is the former FEMA director.
History, I think, was very unkind to you, my friend. Very unkind.
Mr. Brown, thanks for being with us.
This is Michael Brown Unplugged.
Hey, welcome to this episode of Michael Brown Unplugged. Glad to have you with me. Everybody knows that obviously this week is the 18th anniversary of the attacks on 9/11. And of course, on Wednesday, I'm sure we'll talk about that a little bit. But I want to lead off this morning with a story that this is one of those probably instances where I'll talk about a story on both the podcast and on the radio program. And I only do it because I think the case, the story that I want to tell you about, which is a case out of the Eastern District of Virginia, Federal District Court, is of particular importance, I think, in terms of understanding why I'm so adamant about our liberties and our freedoms and individual liberty, and why I'm so adamant in being opposed to making things easier for law enforcement rather than more difficult for law enforcement. And let me explain myself. The reason that we make things difficult for law enforcement is that we give them the ability, and by law enforcement, I want to include the whole gamut of what includes law enforcement. Everything from a beat cop to a local prosecutor to a district attorney, all the way up to, a state bureau of investigation, to U.S. attorneys, to the Department of Justice, to the Federal Bureau of Investigation, and to the court systems. Local courts, local municipal courts that adjudicate whether or not you might go to jail for something, state courts that can do the same, federal courts, all of these court systems and all of this system called our judicial system, I'm kind of lumping together and describing it today as law enforcement. And we make law enforcement difficult because all of that system is designed within constitutional parameters, is designed to give the government the ability to take away an individual's life, liberty, property, pursuit of happiness. Of course, and I say within a constitutional framework, because before you can deprive somebody of life, liberty, property, pursuit of happiness, the Fourth Amendment, the Fifth Amendment, statutes, regulations, the rules of evidence, all provide that you can only do that under a system that presumes your innocence until the government proves your guilt beyond a reasonable doubt, and it puts certain restrictions and constraints on law enforcement. For example, the Fourth Amendment. You just can't cops just can't barge into somebody's home because they suspect that you either have committed a crime or you might be committing a crime, or that you might, in this day and age, that you might be thinking about committing a crime. We make it difficult for law enforcement. And I think anybody involved in law enforcement, while they might to some degree bitch and moan about the fact, Brown's talking about our jobs are hard. At least he recognizes our jobs are hard. I think they would also agree that their jobs should be hard. They have guns. They have the ability, we have guns too, but they have guns that can take away our freedom. They can point the gun at us, and unless we want to engage in a fight and end up with a taxpayer relief shot where I point out, well, you're an idiot because you pointed your gun at a cop who was pointing his gun at you or vice versa, and the cop takes you down, well, tough stuff. We make it hard for law enforcement because they have the ability to take away our freedom. And we say if you're going to take away our freedom, you have to make sure that first you've proved beyond a reasonable doubt that the individual is guilty of the crime charged. And in the process of doing all of that, that leads up to a conviction. We have substantive due process. We have procedural due process. Rules of evidence say certain things are inadmissible. Rules of evidence say that things that might otherwise be admissible, if they are taken improperly or produced or gathered improperly, that evidence might not be admissible in court. And I know that frustrates cops. I know it frustrates law enforcement. But if they're true to themselves, they will say, yes, but we understand why. Because we can take away someone's freedom and liberty, so our job should be difficult. Another way to think of it is this. What if cops' jobs were easy? What if there were no difficulties? Well, you live in a police state probably, and if everything was easy for a cop, well, they'd just pull over anybody, stop anybody, they would investigate anybody, they would do anything they wanted to do with regard to anybody because there are no restrictions on them. So their jobs are naturally and rightfully so difficult. Now, do I think cops, or for that matter, prosecutors or judges are paid commensurate with the difficulties of the jobs that they do? No, but then I don't think teachers get paid commensurate with the jobs that they do. All of these people get paid commensurate with what the marketplace says that we will pay them. If you want to pay cops more, you want to pay teachers more, well then, you can agree to be taxed more, and you can direct that those additional taxes that we pay go to pay increased salaries. But I say all of that to get to this case. The case is El Hadi versus Charles Cable, who is the director, or was the director at the time, of the terrorist screening center. He was sued in his official capacity by 23 United States citizens. And I emphasize that they were United States citizens because those are the only people I really care about. If somebody gets placed on the terrorist watch list or the no-fly list, and it's Abdul from, Syria, I really don't give a rat's ass about Abdul from Syria. Not in this sense. I may care about Abdul in a different way, about other things, but I certainly don't give a rat's ass about Abdul and his ability to claim a constitutional right regarding the terrorist watch list. If you want me to care about that, well, then immigrate to this country legally, become a U.S. citizen, and then I would care because you would be a U.S. citizen. So these 23 U.S. citizens sued the director of the terrorist screening center in his official capacity because they claim that the traveler redress inquiry program, have you ever filled out, you're booking an airline ticket online, and oftentimes it'll ask for your global entry number or your the TSA pre-pass, whatever it might be. It'll ask for that number. And then if you look closely, it'll also ask, do you have a redress number? And the redress number is you've been put on the watch list or the no-fly list, but you have adjudicated that. You have finally somehow, through some miracle that nobody else can do, because maybe your name's similar to somebody that's on the watch list, you've gotten a redress number so that you don't get flagged as not having the right to travel. I have a vested interest in this because a couple of times, while I was the Undersecretary of Homeland Security, my name appeared on the no-fly list. I've told the story 100 times, so here's 101. My security detail and I walk up to the Lufthansa check-in counter at Dulles International Airport in Washington for a flight to Frankfurt. I think we were going on to Moscow or St. Petersburg or something. And I'll never forget the look on the face because here I am. I got my credentials. My security detail has their credentials. We all present our credentials to check in. And the poor little guy working at the Lufthansa counter punches around on his computer, and I can tell he's acting nervous. And he sheepishly looks up at me and says, "Mr. Secretary, I'm sorry, but your name's on the no-fly list, and we can't print your ticket right now." Now, before I could say anything, the security detail stepped in and said, "Well, hang on a second." And so they started making some phone calls. Sure enough, my name was on the no-fly list. Now, to this date, I don't know whether it was just another Michael Brown or whether it was me personally who was on the no-fly list. But regardless of what it was, for that brief moment, had I just been a private citizen, no security detail, no credentials, no title of undersecretary, I probably would not have been able to board that flight to Frankfurt. Fortunately, I was in a position where I could pull some strings and I got everything worked out and was able to board the flight and proceed on to Europe. But I want you to think about these 23 citizens that sued in the Eastern District of Virginia. Their claim was that the ability to challenge the no-fly list did not provide a constitutionally adequate remedy for a U.S. citizen who had been listed on the no-fly list, which is a subset of persons included in the terrorist screening database system that are prohibited from boarding a commercial aircraft that traverses U.S. airspace, and outlined in their case what they considered to be relevant considerations in assessing whether the subsequently revised redress system, which the court concluded was not constitutionally deficient on its face, whether or not it provided constitutionally adequate remedies in order to address being placed on the no-fly list. Now, long story short, this case ended up where both parties were filing motions for summary judgment. A summary judgment is where you say to the court, here are undisputed facts. We've done discovery, we've answered interrogatories, we've looked at documents, we've done everything, and here are the facts that both sides agree upon. And based upon these facts, Your Honor, we're asking you to apply the law and make a decision, and we think the decision should be in our favor based on the law applied to these undisputed facts. So these 23 citizens filed motions for summary judgment saying, we think this is unconstitutional. You don't have to have a trial. You can decide this case on these facts applying this law. The government did likewise. The government said, yes, we agree that these are the facts, but we think you should apply the law and you should rule in our favor. The court ruled in favor of the 23 citizens. And it was in essence a decision that said, you're violating the liberty, the freedom of interest, the freedom of travel interest. You're violating all of these constitutional interests that these 23 citizens have. Now, the 23 citizens, some had names like Abdul. Some had very simple names like Michael Brown. Some were minors, so their names aren't actually listed. They were represented, it was a minor, no name listed. The court looked at all of the facts, and the court said, whoa, this system violates the Constitution of the United States. You have created a list that some people don't even know they're on, so they suddenly show up at the airport like me, and there's no redress. There's no way. You've just decided with standards that aren't put in place to put somebody on the list. You've also decided to put people on the list who are known terrorists. Okay, they're still entitled to due process. You've put people on there that are suspected terrorists. Well, wait a minute. Now we're getting to the point where if you're a suspected terrorist, yeah, they're still entitled to a presumption of innocence. They're still entitled to some sort of due process. And you have put people on there. There's two other categories. You've also put people on the list who you think somewhere down the future, based on all this information, might become a terrorist. Well, now you're really getting into almost like a red flag law. Well, we think you might be a harm to yourself, so we're going to take your gun away. We think you might be a harm somewhere, sometime, somehow to United Airlines or to Air Transportation Security, so we're not going to let you fly. And then you have some people who are on the list, kind of like me, who just randomly appear on the list. The court finally said that not only do these 23 individuals have standing to challenge this law, challenge this list, but they went into, the court did, it went into some very interesting propositions about how procedural and substantive due process should apply. And it outlined, for example, the right to travel. And it goes in how that is one of the basic freedoms that Americans have. We don't have internal passport controls. We don't get randomly stopped. You may have heard me say occasionally when I'm talking about a story, may we see your papers, please. Well, that's a reference to internal passports, where if you live in a communist country at any time, for any reason or no reason, government officials can stop you just randomly on the street. May we see your papers, please? We want to see your ID. We want to know what you're doing here. And suddenly you're facing an inquisition just because you were going to Walmart. We don't do that in this country. We don't have internal passports that say if you're going to travel from, Colorado to Texas, that you ought to stop at a border and get a passport to come into Colorado, although I think we ought to do that with Texans. We ought to say to Texans, well, actually, I'll give a break to Texans. I think what we ought to do is say to Californians, if you want to come into Colorado, you have to get a visa, and maybe we want to, and there's a limited number of visas for people from California to come into Colorado. But I digress. The point of all of that is we don't have that kind of system in this country. We have under the Constitution freedom of association, a First Amendment right. A First Amendment right that allows us to associate with anybody and travel wherever we want to, however we want to. Now, don't even get me started on the driver's licenses, because I think that's a whole different ball of wax, but sometime I'll do a story on driver's licenses. But the point that I wanted us to note on the week of this anniversary of 9/11 is that the Eastern District of Virginia ruled in this case that the terrorist watch list does not provide the kind of due process safeguards that U.S. citizens are entitled to before you put them on a secret list. The court even noted that the criteria for being put on the list remained secret. Now, whether the court had access to it, I have to admit I've only read 29 of I've got 3 pages left to go in the case. So I don't know whether the court ever addresses whether or not it actually had access to the criteria by which you get placed on the no-fly list. But even if it does get to that point and addresses that, it doesn't make any difference to me, because the court said you can't have a secret list that you put people on that violates their First, Fourth, and Fifth Amendments without giving them a process by which they can receive, 1, notification they've been put on the list, 2, the criteria which put them on the list, at least some basic criteria, 3, that you have to have a remedy so that if I want to challenge being put on the list, there has to be a process in place for me to do that. I think this is a huge win in the post-9/11 era, because I think when we consider, which we will on Wednesday, what happened on September 11th, 2001, I'll probably be talking that day in a lot of different venues, cable news and other places, about what's occurred since then. Because we're told to never forget. Now, never forget was originally entered the American International Lexicon because of the Holocaust. Never forget. And then 9/11 comes along, and 9/11 also starts to encompass what happened on 9/11. Never forget those firefighters, those cops, those individuals, the people in Flight 93. Never forget them. And so I think what we need to do is take that lexicon of never forget, and yes, it should be a moment of remembering what occurred that day. But I also think that we should reflect on where we have gone as a nation post 9/11. The Patriot Act, a no-fly list, almost like a star chamber that you can get on that prohibits your freedom of travel. And finally, after 18 years, a judge in the Eastern District of Virginia, Judge Anthony Tringa, finally says, enough is enough. And yes, it violates the First, Fourth, and Fifth Amendment. So DHS, FBI, the terrorist screening centers and the terrorist screening database. If you want to maintain this list, you've got to provide these legal constitutional remedies for U.S. citizens. I think that's the kind of thing that America needs to do, because we have reached a stage where I believe this very, very sincerely. I think Americans have been taught to live in constant fear that something bad's going to happen, fear that lurking around every corner is an active shooter, fear that around every corner is a terrorist ready to blow something up, fear that, there's a white supremacist group or there's a far left Antifa group, that there's everywhere, that there are all these dangers. And I'm not saying that each of those dangers doesn't exist, because each of those dangers does exist. But for the vast majority of us, those things are never going to happen to us. But if everybody lives in fear, you're much more willing to give up your liberties in exchange for a little security, and eventually you start giving up more and more of your liberties for what you believe is more and more security. But I would ask you to think about anybody living in a police state, just how much security they have. Or for that matter, anybody living in a prison. You would think a prison would be crime-free. They're anything but. I'll always choose to live in liberty. I don't want to live in a police state. And I think that this occasion of 9/11 is far enough away from the tragedy that it's time to do a little introspection about where we've gone as a nation. And this case, if for those of you who want to look it up and read it for yourselves, I would encourage you to do so. It's Anas, A-N-A-S, El-Hadi, E-L-H-A-D-Y, Anas El-Hadi versus Charles Cable, K-A-B-L-E, and it's in the United States District Court for the Eastern District of Virginia, the Alexandria Division. And I'm sure if you plug that into your search engine, plus the word text, you'll find a copy of it. Several news organizations have it. They have a hyperlink to it. You should go read it. It's a good lesson about the Constitution. It's a good lesson about the First, Fourth, and Fifth Amendment. It's written in such a way, this judge has written a fairly clear, clean-cut opinion. You can skip all the citations when they start doing it. Just read through the dicta, read through the narrative of the judge, and I think you'll learn a lot. And I think on this week of September 11th, you should do that. Hang on, I'll be right back. That little twerp David Hogg is back in the news. He says that America is violent because of white supremacy and because of a genocidal government. Here's the deal. Here's my take on David Hogg. One, he's one of the useful idiots. He's a product of public education. He's also a product of, obviously, liberal parents. I think his dad is actually an FBI agent or something, but don't hold me to that. But now this far-left activist says that America is violent because of our history of white supremacy and because the U.S. government is genocidal and has committed indigenous mass shootings. Indigenous mass shootings? That we've done that? He says that it's okay to hate injustice and oppression because that's what America was founded on.
Culture that is a very violent culture, America. Like, how do you and the movement think about that?
I think it comes down to reckoning with our history and our history of white supremacy in the United States and the fact that we live in a post-genocidal society, oftentimes that was orchestrated by the United States government, and that if we want to talk about mass shootings, we have to recognize the massive number of indigenous mass shootings that were committed by the United States government. I think back to the...
let's just say, if you understand the Trail of Tears, and if you understand Manifest Destiny and some of the horrific things that Andrew Jackson did, how many of you were alive during that? How many of you were alive during that? I think about my grandfather, who was a Cherokee Indian, and he and my grandmother both, all of my grandparents, loved this country to the depths of their souls, they love this country. And on his side of the family, they were subjected to the Trail of Tears, and yet they held no ill will. Why is it that any of us living today who have not been a part of anything that this nation did that we might consider genocidal, that we might consider to be, well, we really shouldn't have done that? How many of us can really directly say, yeah, our family, I can trace my roots back to XYZ, and they were either a part of that or subjected to that, and even if they were, it's 2019. I think people like David Hogg are like, we had dinner over the weekend with friends whose son had broken up with a girlfriend, and he had met another girl, and I said, well, has he started dating her? And they kind of laughed and said, no, because they were talking somewhere, and all she could do was bitch about her old boyfriend. And he was like, I don't want anything to do with, if she's going to be that way and continuously bitching about something in the past, and she can't get over that and move on, and she has to tell me all of that, that tells me what kind of person that individual is. David Hogg is kind of like that. Although he's never been involved directly with a horrific boyfriend or girlfriend situation or an abusive boyfriend or girlfriend. Maybe he has and I don't know it. But for him to sit there with, what's the Hayes from MSNBC, Chris Hayes. For him to sit there with Chris Hayes on MSNBC and claim that America is somehow horrible because of indigenous mass shootings and that he's somehow suffering from that, he's been taught that. He hasn't learned that from family or anything else. He's been taught that in an educational system somewhere that says that America is a bad place. As long as we continue this kind of educational system that creates these kinds of useful idiots, I'll be long gone. You'll probably be long gone. But at some point, we're going to start reaping what we have sown with these kinds of rugrats that have no sense of history, that have no sense of understanding that, yes, like any individual that has flaws, this country has flaws, but the good this country has done far outweighs those. And like that girlfriend of our not the girlfriend, but the potential girlfriend of our friend's son, if all we're going to do is bitch about how bad this country is, I really want nothing to do with you.
The Battle of Wounded Knee and the several hundred Native American, predominantly men, women, and children that were slaughtered by the United States government back in the 19th century, and how that's never discussed as a mass shooting, right? And that's wrong because those people were not armed and we were stealing their land. I think it comes down to reckoning with a tough history and realizing that it's okay if you recognize the actual history of the United States, it's okay to hate that injustice that much of this country has been founded on and much of the oppression that this country was founded on. That doesn't mean you hate America, because it means that you love your fellow Americans so much that you don't want to repeat the same mistakes we've made in the past.
We're not repeating those mistakes. No way are we repeating those mistakes of the past. But I wouldn't expect him to understand that or to know that. Rich Lowry was on This Week yesterday, George Stephanopoulos' program, and they decided it was time to talk about Sharpiegate. You know, the whole video, or not the video, the whole, well, it was a video of President Trump talking about how, or at one point he made a comment that Hurricane Dorian may impact Alabama. And then he and the acting Secretary of Homeland Security in the Oval Office and Trump, rather than just relying on the original forecasts of Dorian, instead he had to hold up a map in which they had put the cone of probability, taken a Sharpie, and extended that cone out so that it enveloped part of Alabama to make his case. That was totally unnecessary, and I'll explain why. But first, I want you to hear what Rich Lowry had to say on ABC's This Week with George Stephanopoulos.
And Chrissy, I think it's entirely possible that first briefing the president had, whatever it was, 10 days ago now, said, and it might hit Alabama. There's no question that when he tweeted last Sunday, Alabama's going to get hit harder than anticipated. That's flatly just not true. What I don't understand is sticking with it for 7 days after that. What is that about?
Well, listen, I think that this president has shown over and over again that he believes that admitting mistakes is admitting weakness. And I don't think it's hard to understand him. People seem mystified by this, and I'm mystified by them. This is who the President of the United States is. I've known him for 18 years. Why want
this to be part of the dialogue for 7 days?
Listen, because it drives you guys crazy. But I think, and the media focuses on this instead of focusing on what Ron was just talking about or other issues. We're talking about this before we're talking about Afghanistan and negotiations with the Taliban.
We led with Afghanistan. We'll talk about that.
But my point is, though, that this is what lots of folks in the media talk about, and it's a distraction. And I don't think the president necessarily thinks that distraction is bad for him.
But we talk about it because he's talking about it. I mean, he was just relentless in his justification of this. And it wasn't just that he, wouldn't let this go. He's also deploying government resources to help in his argument. And when you're facing, a hurricane of significant consequence, you have to think about, how much time and effort was spent defending the president's argument here versus focusing on some other key issues.
But he's talking about it because you're talking about it. It's like this circle that never ends. And he never allows himself, as Chris points out, the escape route. Oh, it's old information. I revise and extend my remarks. But that the media was analyzing this with the detail of the Zapruder tape was completely absurd. And it was totally lost that the major story was actually a Category 5 hurricane had devastated the Bahamas and was threatening the east coast of the United States.
But we should.
Rich Lowry is right. They're analyzing it like the Zapruder film. Maybe that's a reference I should explain. The Zapruder film is a 8mm video of the Kennedy assassination taken by a gentleman whose last name was Zapruder, and it Zapruder, if you want to look it up. And it has been analyzed. In fact, you can go online and you can find frame-by-frame analysis of the film, including the kill shot delivered to President Kennedy. I think it's a great analogy. They're analyzing it just like the Zapruder film. But I've gone back and I've actually studied this. And I would just like to say to the president, Mr. President, you had a fantastic opportunity to troll the media over your comments about this storm, Hurricane Dorian, hitting Alabama. If you go back and you look at the NOAA predictions, if you go back to the National Hurricane Center, you can see where the cone of probability originally showed. In fact, I remember hearing this because I thought to myself, oh, crap. I knew anyway, because there was a hurricane, I was going to get called to go talk on national television, the cable stations, about the hurricane, which, of course, that is what happened. But when I first heard about Dorian, several of the models showed the hurricane, and I specifically recall several meteorologists and the National Hurricane Center talking about one of the probabilities is that Hurricane Dorian will go across the Florida Peninsula, weaken, and then hit the extraordinarily warm waters of the Gulf of Mexico, where it will strengthen once again into a potential Category 5 hurricane and hit Alabama, Mississippi, and horrors of horrors, once again striking a Cat 5, although Katrina was not a Cat 5, a Cat 5 hitting New Orleans. I remember that specifically. If you go back and you look at the cone of probability when those projections were first being made, yes, the National Hurricane Center and NOAA were projecting that it could go across the peninsula and that it could hit Alabama, Mississippi, and Louisiana. All the president had to do he didn't have to get a Sharpie out. All he had to do was say fake news and go back to the National Hurricane Center, because they have archives of all of their predictions, and show, yes, at one point they thought that one of the options, one of the tracks took it into the Gulf of Mexico, strengthening and becoming a problem for Alabama, Mississippi, and New Orleans. I think Chris Christie's right. The president has a hard time admitting when he was wrong. But in this case, he was not wrong. He probably heard that just as I heard it. He didn't need a Sharpie to prove it. All he needed was to go back to the National Hurricane Center. Do you know who I fault for this? The staff. All the staff had to do was, hang on, Mr. President. We heard the same thing. Put down the Sharpie. Step away from the Sharpie, Mr. President. Don't touch it. Let us get the evidence for you. And Sharpiegate would have been nothing. And he could have legitimately called them fake news instead of getting distracted by drawing of that black Sharpie on the map. Bad staffing will get you every time, Mr. President. Find out who didn't point that out for you, because, frankly, they ought to get their butts fired. Thanks for listening to this episode of Michael Brown Unplugged. Be sure and tune in weekdays from 2 to 4 p.m. on 630 KHAL, or on the iHeart app, or on Spreaker. We have yet to get the radio programs podcast up on iHeart. Don't ask me, but we're working on it. And you'll be able to download that podcast also, or you can just listen live. But again, thanks for listening. You know the drill. Leave us a 5-star rating, leave us a review on iTunes, and follow us on social media by simply going to michaelbrowntoday.com. michaelbrowntoday.com. Again, thanks for listening. I'll talk to you tomorrow.